Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Here we go. All right, State of Michigan versus Yousef Moore, case 24057325501. Today is the date set for a bond redetermination hearing. Appearances, please.
Sherry Wyrick on behalf of the people, P77976.
Good morning, Your Honor. Ashley Plessis, P82896 on behalf of Mr. Yousef Moore. Mr. Moore, can you state your full name for the record, please?
Yousef Moore.
Thank you.
All right, good morning, Mr. Moore. Today is the date set for a bond redetermination hearing. The bond is set intentionally unaffordable. Mr. Plessis, are you making an argument as to bond?
Yes, I am, Your Honor. Ready when you are to proceed.
Yes, ma'am, go for it.
Thank you, Your Honor. When analyzing the factors under MCL 765.6, I do believe that Mr. Moore is a candidate for community supervision. The $1 million bond is entirely unaffordable for him. He is the sole provider of his family. He has a wife and a 7-month-old son. She is a stay-at-home mother. He is responsible for all finances, so there's no one who is able to post bond for him. Obviously, he's charged with a serious crime. Whether or not that'll be proven at preliminary exam is another matter. However, for protection of the public, he is someone that could be supervised by GPS tether. He does not live in the same city as the complainants. He is a resident of Southfield. He has absolutely no previous record. He was a CPL holder at the time and was legally able to carry his firearm. My client is a graduate of the University of Chicago and previously worked for the Detroit City Law Department. He currently owns his own business that requires him to travel throughout the state. One important thing to note about this case is he turned himself in before a warrant had ever been issued, before the police had to come and talk to him. It's our theory he was acting in self-defense at this event. He tried lesser means to ward his attacker off, such as mace. And then he was able to retrieve his child and his wife and get them to safety that Saturday. However, Monday morning at 5 a.m., he's turning himself in to the Detroit City Police with the firearm in question so that they could take that into custody as well as himself, and he could handle this case. That's not someone who is a flight risk or a danger to the community. That's someone who wants to come and take care of this matter before it got any worse. There is nothing to suggest in his history that he would be a further danger to the community. There's nothing to suggest that if he was released onto tether so he could continue working during this case, that he would be unable to follow that. And we certainly know he'll appear to court if he's turning himself in before a warrant's ever issued. So I would ask that you take all that into consideration with setting the bond, particularly the means to maintain public safety through GPS tether monitoring. Thank you, Your Honor.
All right, thank you, Mr. Plessis. Ms. Wyrick, do you have an argument as to bond?
Yes, Your Honor. The bond was intentionally set unaffordable because he is a serious danger to not only the victims, but to the community. There's a high likelihood of conviction in this case. Several witnesses that know him picked him out as the shooter. The gun was recovered. He fled the scene. He did turn himself in 2 days later with a written story he made up claiming self-defense, which is not even close to what the multiple over 5 witness statements gave at the scene. He's a danger to the victims. They're known to him. He knows where they live, and he's threatened to kill them already. He's a danger to the community. The shooting occurred at a baby shower. with multiple people in the line of fire, including several small children, even including his own child and the child's mother immediately next to the victims when they were maced and shot at. So according to several witnesses that did stay on the scene, the defendant shouted, "I'm going to kill you," while firing 3 times at his first victim, and then pointed the gun at a second victim, stating, "I'll kill you too," and pulled the trigger some more. Fortunately for everyone there, his gun jammed and the magazine fell out of the gun. He attempted to put it back in the gun and was unable to do so. He registered that gun only 2 months ago, and it seems that he just couldn't wait to use it. The fact that only one person is shot is not for the defendant's lack of trying, but for the gun malfunctioning. And this very likely could have been a multiple homicide. I also want to add that, defense is saying that, he was being assaulted, but where are these witnesses? He stated the written statement that he brought to the police. He wrote, "Call my baby's mother." They attempted to do so, and she elected not to give a statement. So, and we were here for the arraignment. We were both, Attorney Duplessis and I were both at the arraignment. Same arguments were made as to bond. I believe the bond is appropriately set to protect not only the victims, but also the community.
All right, anything further, Ms. Duplessis?
Yes, Your Honor, just briefly, I know we're not here to litigate the case, but I will state, according to the police's own report, they could not recover more than 1 shell, which does go against this theory that 3 shots have been fired. The complaining witness told the police, "Y'all better find him before I do." And that is the only statement he would give, which also indicates an aggressive person. I can't speak to why the police didn't interview the other witnesses, but rest assured my team and I will be. We'll be presenting them. But I do believe that there is enough evidence to support self-defense at this time. And furthermore, looking at the bond factors by statute, it does support his release into the public.
All right, give me 1 moment to review the investigator's report.
Thank you.
All right. Haven't had a chance to review the investigator's report, and I review these reports not to determine the facts of the case, but get an understanding of, what kind of incident took place and kind of the tenor of what happened. I would note that this is allegedly an assault or a shooting that took place at a family party with the complaining witnesses and the defendant all knowing each other, as well as the fact that it did not seem to be it does not seem to be a situation where this is an ongoing dispute or anything like that. But I would note that this is allegedly a shooting that took place at a children's party. There's at least one person injured or shot, and possibly others involved. Now, there are 2 sides to every story, but in this matter, I do not feel, I do believe that there's enough in the investigator's report relayed by Ms. Wyrick to believe that there is a safety to the public or danger to the community while this matter is pending, and bond is going to remain the same. There are at least 5 witnesses that made statements as to what they said happened. Ms. Wyrick indicated that there was an attempt to get a witness who could possibly confirm Mr. Moore's version of the events, which we don't have at this point. Not saying that that would change anything, but it definitely might. And if that changes, the exam judge can make that determination. But at this time, I believe that the $1 million bond, which is intentionally unaffordable, is essentially a remand, but that's what I intend to do at this point. I think we've met that standard and bond is going to continue.
Thank you, Your Honor. In regards to the no contact order, can we just make sure that it's clear that that's no contact with any witnesses in the case?
I don't have a
No
witness
third
list.
party contact, obviously.
I don't have a witness list. All I have are the two complaining witnesses on the investigator's report.
Okay, can
So-
we add a third name to the no contact order? Amaya, Amiya. Last
Who is
name
this?
Alexander.
Who is Amaya Alexander?
She
Is that
is
the
a
family
witness.
member eyewitness?
Eyewitness, right next to the victims. Pretty much a victim herself.
Is this a minor or is this an adult?
She, I believe is, I don't know her age. I believe 18.
Okay. I just want to make sure it's not.
Not a minor, no.
All right, the next date is before Judge Sabri on May 29th at 8:30.
Thank you, Your Honor.
Thank you, Your Honor.
All right, that concludes this hearing. Person on the 8th floor, ma'am, can you tell me your name? They gotta have you unmute or unmute your device.
Nicole Ingram.
All right, Miss Ingram, 1 second. This is State of Michigan versus Nicole Ingram, case 24057-33601. Today is the date set for a bond redetermination hearing. Appearances, please.
Judge, good morning. Always a pleasure. Steve Vincent for the people, P 71917.
Judge, I think Miss Ingram, did you have counsel? Did you have retained counsel?
The last one, yes. The last time I was before a judge.
Who was your attorney, Miss Ingram?
I don't know whose the attorney is now.
I don't believe that I don't think there's a retained counsel on this one.
Judge, can I have a quick breakout room with Miss Ingram then?
Yes. I think NDS is assigned, but it's definitely not retained. Back to the breakout room.
Okay, whatever you want to do, Judge, I'm ready.
Okay, I can call Mr. Zorn. This is State of Michigan versus Demarcus Zorn, case 23060620001. Today is the date set for a bond redetermination hearing. Appearances, please.
Thank you, Judge. As always, it's a pleasure. Steve Vincent for the people, P 71917.
Celebrating on behalf of Mr. Zorn, who's here for bond redetermination, Judge.
All right, Mr. Zorn, good morning, sir. Could you state your name for the record?
Dr. Zorn.
All right, thank you, sir. Today is the date set for the bond redetermination hearing. Bond is set intentionally unaffordable. Appearances, please. Oh, we put the appearances on. Mr. Reagan, ask the bond.
Judge, what do you have as bond? I have some cases. It's a CCW case. What do you have as bond, Your Honor?
50,000, 10%, which was set at the arraignment.
Yeah, so I'm asking for a personal bond, Judge. It's a CCW. I would note he does have, he was on, I believe, probation for a CCW. That may have been why, it was set for.
Yeah, I set this one after 2 cases on this matter.
Right. I was going to say.
It's a flight risk.
I was going to say, I have 3 cases. So I'm asking the court judge to put a tether on Mr. Zorn, but to give a personal bond so we can keep track of Mr. Zorn and know where he is to avoid any flight situation, Your Honor. So that's what I would ask. I don't see any assault of history outside of possessing a firearm where he should not be allowed to have done so. But flight risk definitely, tether definitely. I'd ask the court respectfully for that.
Well, I set this bond at an arraignment at 50,000, 10% to make sure that the defendant had a 10% provision on the bond. This case by itself, which was originally arraigned in December of 2023, had two capiases before Judge Jefferson on a personal bond. And at this time, cash bond is necessary to ensure the defendant shows up to court. So that's why bond is set at 50,000, 10% with the understanding that this is the least restrictive means I can make sure that the defendant comes to his court date. We had two bites on the same case. So bond is going to remain the same.
Right, but Judge, I think a tether. I mean, I know the court position a lot of times with tethers in terms of with non-assaultive cases. If we talking FAA, but it's a CCW, and I think, Judge, if you put a tether on,
this is a straight up flight risk on a case that the defendant missed two was capious twice. On this 2023 case, he could have been resolved this. Actually, this is a CCW felon in possession as well. You indicated that he's on probation, which I didn't even have.
Right.
Yeah, 50,000, 10% is more than reasonable. All right, this matter is concluded. The next date is before Judge Jefferson. Let's see. May 20, strike that, Judge, before Judge Sabri, May 29th, 2024.
Judge, can I get a quick breakout room, Mr. Zorn, real quick?
Yes. All right, Ms. Ingram, I'm sorry I was on mute. Can you hear me now?
Yes, sir.
All right, State of Michigan versus Nicole Ingram, case 24057-33601. Today is the date set for a redetermination hearing. Appearances, please.
Thank you, Judge Stevenson, for the people.
Your Honor, break it on behalf of Ms. Ingram, who's here for bond redetermination.
Ms. Ingram, could you state your name for the record?
Yes, Nicole Ingram.
All right, thank you, Ms. Ingram. Today is the date set for the redetermination hearing. Mr. Reagan Esteban.
As the bond judge, it's interesting. I get a chance to speak with Ms. Ingram. I look at what the charges are. First thing I want to say, it was never a knife involved in any of this stuff. No knife, nothing like that. It's kind of funny. I think there was a lot of drinking going on. I noticed that there were several different statements made, statements changed, people, saying different things. Mr. Penson, who's I guess home it was, saying that he was assaulted by the complainant and the defendant at some point, then changing the story. My client tells me she comes over to wash clothes and, she's just washing clothes. And this young lady comes and she comes and tries to attack Mr. Penson, the complainant. He's like, who is this lady here? Why is she here? And my client's just like, I'm just like here washing clothes. She has another friend with her there. So it's 4 people. And the other girl gets irate at Mr. Penson for having Miss Ingram over there. Then she turns to Miss Ingram. She comes at Miss Ingram. They start to tussle. Miss Ingram does have some keys in her hand, Judge. So that may be where she got scratched from or a scar from or whatever. But Miss Ingram says she doesn't know this lady. She wasn't trying to be aggressive with this lady. Mr. Penson contradicted his story a few times when he went to the precinct about what actually happened. I just don't think it's a AWIM GBH FA, Judge. I think it was something that Miss Ingram told me that happened. She didn't start anything. Somebody came at her, and I don't think it's necessarily cash bond. Now, her and Mr. Penson have a history. They got a history together, Judge, but she doesn't know this lady. And I'm asking the court to consider personal bond for her, Judge. Just no contact with Miss Artist, Judge, who she really doesn't know.
All right, Mr. Vincent.
And Judge, I say this with all, and thank you. I say this with all due respect, and I'm not trying to be snarky here. Then I guess what happened, just based on defense counsel's interpretation of this, she stabbed herself in the forehead. And whether it be a knife or a prick or some type of shank, allegedly, then that's what happened. Now, Judge, I do want to just bring to your Honor's attention a couple of things. In addition to this case, this defendant has an ongoing DV case, and she has multiple cases in that case as well. That has an offense date of 6/13/23, different complaining witness in that case than in this particular case, Judge. Now, ironically, she wasn't out on bond at the time of this incident. She was out on a habeas warrant because she had failed to appear. She was just arraigned the other day on the DV, as well as this particular matter, Judge. In addition to the fact there is a likelihood of conviction here because we have an identification from the individual, pushing everything aside. We have injuries, we have identification, we have a gal going through a case that has habeas history. Judge, I could argue danger, I could argue flight. I'll argue both and request your Honor just continue this.
And Judge, I don't know, maybe Mr. Vincent didn't hear me, but I did say that she had keys, wasn't a knife, you know, and the complaint came at my client. She just defended herself. So I'm going to repeat it because I thought that's what I said the first time. So that's our interpretation of Judge, what happened.
Well, I think both of your interpretations are something to be desired. First, I would start that it was described by the complaining witness in this matter as a prison-style shank, but I'll leave it at that. And I would note that there is a pending domestic violence charge, but that is against the complaining witness who refused to press charges in this matter. I would note that it seems like this is an incident that was I believe that this is a dangerous situation, a situation where I fear the safety of the public, but I don't believe that could not be controlled without a cash bond means. So I'm going to amend the bond to $50,000, 10%, strike that $50,000 personal with a GPS tether. Miss Ingram, you're to have no contact with both complaining witnesses in this matter, Mr. Pinson and one second. And Ms. Artis. Ma'am, while this matter is pending, no contact with that. Are you living there at the time?
No, I was just washing clothes.
All right, well, then it makes it easy. No contact with that address. Ms. Ingram, do you have any questions?
No, sir.
No, Judge.
So, ma'am, I got to tell you, you got a habeas warrant out now on a domestic violence case. And now you have this matter, which is also involved the same complaining witness. You know, you're running out of lifelines here, if I can be blunt.
I understand, sir. I've been in no contact for 9 months. It's just
whoa, okay. You understand? That's all you got to say. You understand?
I understand.
All right.
I understand.
All right, next date is May 30th, 2024, before Judge Sabri.
Thank you, Your Honor.
Thank you.
All right, that concludes the hearing.
Thank you, Judge. Phil, I'll give you that one. I guess I had the lesser desirable interpretation of that case.
Ma'am, can you tell me your name?
Priscilla, Southall.
All right, 1 second, Ms. Southall. All right, State of Michigan versus Priscilla, Southall, case 24057-33301. Today is the date set for a bond redetermination hearing. Appearances, please.
Good morning, Steve Vincent.
Break it on behalf of Ms. Southall, Your Honor.
All right, Ms. Southall, could you state your name for the record?
Priscilla, Southall.
Thank you, ma'am. Today is the date set for the redetermination hearing. Mr. Reagan Esteban.
Judge Esteban, my client's 32, no prior criminal history, Judge, to my knowledge, no pending cases. She's actually has 5 children, Judge. Mother 5, lives in the city, has her whole life. This is something, Judge, that arose, I think, out of a family function. Now, Miss Southall is at home. This is her house. These are individuals coming to her house. And the complaint witness, this judge, she's saying, are fabricating this, to the highest level. The complaint should have never, ever been in Miss Southall's house in the first place. I think there was some type of incident that occurred over Facebook, Judge, a few days prior, some type of argument or beef. And the complaints decided that they were going to make their way over and start trouble with Miss Southall. She didn't go to them. She didn't try to go start anything. And allegedly, this stuff broke out, everything broke out how it did. But it's not what it seems in terms of how it is written. When we talked to Miss Southall about it, she says it's absolutely not true the way it's written. And I think, Judge, once it comes out, the court will see that. I mean, obviously, everybody has their day in court. They have a right to a fair hearing or a fair trial. But while we're waiting for that, I think the court can use less restrictive measures because Ms. Southall is not going to go and seek these people out. She's going to stay at home and take care of her 5 children, if the court allows it. I think based on her lack of prior history, her lack of prior assaultive history, the court could do that, Judge. She's innocent until proven guilty, and I think the facts will come out once this case is adjudicated. So I'm asking for reduction, in bond to personal bond with whatever other conditions the court wishes to impose. Again, I think the way this is written, it's according to Ms. Southall, is totally false, Judge.
All right, Mr. Vincent.
Judge, this is an AWIM case. There's a $250,000 cash bond. I believe there's monitorization as well. Actually, I don't know if monitorization was given as part of it. But the way that I look at this, Judge, just cutting through things, no pun intended. There were multiple times.
You totally intended that pun. Right?
The cut?
Yeah.
No, I didn't. No, I said it, and then I said, "Oh my gosh, I can't believe I just said that." But sometimes it's a Freudian slip. I apologize about that. There are multiple cool down periods here. I mean, we have originally this assault with a glass mug. That didn't work. So allegedly, defendant goes back into her residence and gets a gun. Then comes back out, cocks it. She had to be restrained. Not successful with the gun, gets a machete. Then allegedly successful with the machete, slicing this individual's neck and forehead. So at any one of those points in this incident, Judge, this could have been quashed. It was like the defendant was on a mission here. And she succeeded in her mission. So respectfully, Judge, I don't know how you can interpret that any other way. I understand the incident happened at her house. I understand that defense counsel selectively uses the investigator's report when it's to his advantage. But Judge, this at multiple given points, this could have been reported.
No,
but it wasn't, Judge. So we have ID. You talked about the tenor of what happened. I believe there was a pretty substantial assault here, Judge. Tether house arrest is just putting her back at the place of incident. Seems like it's an ongoing matter. It seems like there's a danger at the very least to this complaining witness. And respectfully, Judge, just based on all of that, we would ask you to continue.
All right. I'm having a chance to review the investigator's report. Well, let me ask you this, Mr. Vincent. If you know, do the complainants and the defendant, it sounds like there was an ongoing dispute on Facebook before this incident?
I read just a few days prior, Judge, that there was some type of verbal argument on the virtual airwaves, but that's what I have.
Okay. This is what I'm going to do. I'm going to amend the bond to $250,000 personal with the GPS tether house arrest. I do believe that I can assure the safety of the public with a non-cash bond. These are very, very serious allegations, and we don't know what would have happened. But the fact is, this is the incident happened at the defendant's home. No indication that there was any reasons for the complaining witnesses to be there. And, quite frankly, the investigative report alludes that there was some ongoing dispute between these two people to begin with. So I don't know why they're at the house at this time. But for the safety of the public and to make sure that this does not get out of hand right now, Ms. Southall is going to remain at the house while this matter is pending. Ms. Southall, are you working right now?
I don't go back to work to July the 1st, but I have 2 autistic kids that go to school in Dearborn. I take them they gotta be there at 9 to 4. And I have a newborn. She goes to school, daycare 8:15 to 2:40. And I have 2 other kids that go to school from 8:15 to 3:30.
I will allow an exception for you to transport your kids to and from school while this matter is pending. Do you understand?
Yes, but I also have a question. What about the doctor's appointments? Do I have to call and let y'all know, or how does that work?
So that's a good question. So school and doctor's appointments while this matter is pending.
Okay, and I don't start back to work till July the 1st. So there's not a problem right now. I'll let you know when I start back work.
So at this point, this is the last time you'll probably see me. You'll have a different judge while this matter remains in district court that you're going to have to deal with. So make sure you let your attorney know what you need as far as a condition, and they'll make an argument and the judge will make a decision.
Okay.
Ms. Southall, your next date is going to be May 31st, 2024, before Judge Giles.
Okay. It's inside the courthouse.
I believe that's going to be on Zoom. They're going to give you some information as to at least that hearing.
Okay.
Mr. Reagan, is there anything further on this one?
No, Your Honor. Thank you very much.
Mr. Vincent, is there anything further on this matter? All right, then that concludes this hearing.
All right, thank you.